When things go wrong and somebody gets hurt or something gets damaged, how does the law decide who's to blame? You might think it's all about proving someone was careless, but sometimes the answer is way simpler and a whole lot stricter.
So, picture this. Your neighbor decides to build a fancy new koi pond. They do everything by the book, they're not sloppy at all, but something goes wrong and it floods your basement. You're looking at thousands in damages. So who pays? Are you just out of luck because they weren't technically careless? Well, the law's answer might just surprise you, and it all starts with a very old, very powerful idea.
And that answer starts with a legal concept called strict liability. You might also hear it called the keep at your peril rule, which sounds pretty intense, right? It's a principle that basically says, look, some activities are just inherently risky, and if you choose to do them, you own the consequences, period.
So what is strict liability, really? It's this powerful idea that if you bring something onto your land that isn't naturally supposed to be there, and it escapes and causes a mess, you're on the hook. And here's the real kicker. It doesn't matter one bit if you are being careful. The focus isn't on your actions, it's on the risk you created just by doing the thing in the first place. Now, what's so interesting is that this whole idea comes from a very specific and kind of wild case way back in 1868. It's called Rylands vs. Fletcher. A guy built a big reservoir on his land, but little did he know, underneath his property were these old, forgotten mine shafts. So the second he filled that reservoir, the water burst through the shafts and completely flooded his neighbor's working coal mine. The court decided that even though he wasn't careless, he brought something dangerous, a massive body of water, onto his land, and when it escaped, he was liable. But, okay, this rule isn't totally absolute. The courts did carve out some important escape hatches. For example, an act of God, we're talking about a once-in-a-century earthquake that nobody could have planned for, that could get you off the hook. Or an act of a stranger, like if a saboteur deliberately came and broke your dam. The law also looks at whether the person who got hurt actually consented to the risk, or if the risky thing was for the common benefit of both people, like a shared water tank.
This got you thinking, though, doesn't it? What happens in our modern world with activities that are so unbelievably dangerous that allowing for any exceptions just feels like it doesn't go far enough to protect people?
And that very question led the law to evolve into an even tougher rule. This is where we see the shift from strict liability to something called absolute liability. And this wasn't just some theory, it was a change driven by a real-world catastrophe.
The big turning point was the Bhopal gas tragedy in India back in 1984. A toxic gas leak from a chemical plant led to thousands of deaths and injuries. It was a disaster on an almost unimaginable scale. And in the face of that, the courts realized that the old rule, with its list of convenient exceptions, was just not equipped to handle the risks of ultra-hazardous industrial activities.
And this is what led to the birth of absolute liability. And I mean, the name really says it all. If you are running a hazardous operation, like a chemical plant or a nuclear facility, and something goes wrong, you are responsible for the harm. Full stop. There are no excuses, no exceptions. None. So let's just put them side by side to make it super clear. On one side, you have strict liability. It's from 19th century England, it's for the non-natural use of land, and it has a handful of key exceptions. On the other side, you have absolute liability. It's from 20th century India, it applies to hazardous activities, and it has, you guessed it, zero exceptions. You can really see the law evolving toward greater corporate responsibility. And why create such an ironclad rule? Well, this quote from Justice Bhagwati, who was a central figure in establishing this principle, explains it perfectly. He said it's about a social obligation. If a company is going to profit from a dangerous activity, it has to bear the cost when things go wrong. It's also meant to have a massive deterrent effect, to push these companies to maintain the absolute highest safety standards possible.
Okay, so we have these rules for figuring out who's to blame, but how far does that blame actually go? Does it just stretch on forever, covering every single ripple effect from one single action? The law says no. There are limits. I mean, think about it. A driver makes a small mistake, causing a little traffic jam. A surgeon gets stuck in that traffic and shows up late to the hospital, and a patient suffers because of it. Is the driver responsible for what happened to the patient? It's a crazy chain of events, right? The law has to draw a line somewhere.
And this is where the idea of remoteness of damage comes in. The old way of thinking, the directness test, said you were liable for all direct consequences, no matter how bizarre or unpredictable they were. But the modern test, the one we use today, is all about foreseeability. You're only liable for the kinds of harm that a reasonable person could have actually predicted might happen. Predictability is the name of the game now.
The classic case here is one called the Wagon Mound. A ship negligently spilled oil into a harbor. Okay, it's foreseeable that the sticky oil will damage the docks and other boats, right? But then, some floating debris carried the oil over to a wharf where welders were working. A spark hit the oil, and the whole thing went up in flames. The court decided that while the oil spill was foreseeable, the massive fire was not a reasonably foreseeable consequence. So, the ship owner wasn't on the hook for the fire damage.
So now that we've figured out who's liable and what they're liable for, how does the law actually fix the problem? This brings us to the final piece of our puzzle, legal remedies.
Generally speaking, there are two main ways to get a solution. You can either go to court and get a judge to order a remedy, or in some pretty specific situations, you can actually take matters into your own hands with what are called self-help remedies.
First, let's talk about the court-ordered remedies. This is when the judge steps in to fix things. The two most common are injunctions and specific restitution. An injunction is a powerful court order that basically says, stop that, like telling a company to stop polluting a river. Specific restitution is an order to give something back, not the money value, but the actual thing that was taken, like a stolen piece of art.
Yeah, an injunction is a really powerful tool. It can be prohibitory, like a judge ordering a factory to stop dumping waste, or it can be mandatory, forcing a landlord, for example, to start making legally required repairs to a building. It's all about preventing or stopping harm in its tracks.
Then you've got these self-help remedies, where the law lets you take matters into your own hands, but you gotta be careful. If someone is trespassing, you can peacefully re-enter your own land. If someone grabs your bag, you can use reasonable force to get it back. There's even this incredible old remedy with a wild name, distress damage faisant. This allows you to temporarily seize a trespassing animal that's actively causing damage, like your neighbor's goat eating your garden, and hold it until the owner pays for the damage.
But, and this is a huge but, here is the big, bright, flashing warning sign. The absolute key to all self-help is that it must be reasonable. You can't use excessive force, and you can't cause a public disturbance. The law gives you a very limited right to help yourself, but it demands you do it peacefully and responsibly.
So there you have it. From the flooded mines of 19th century England all the way to the huge industrial disasters of the 20th century, we've seen how the law has to constantly evolve. It's this fascinating balancing act between assigning responsibility for risky activities, limiting that responsibility to what is foreseeable, and then providing practical ways to make things right.
And that leaves us with one last thought for the future. Right now, we are entering an age of AI, self-driving cars, and autonomous drones. So what new hazardous activities are going to emerge? And will these new technologies demand a new evolution in the law? A new kind of absolute liability with no exceptions? That is a question our courts will definitely have to face, and probably very soon.